members of the court do not have a copy yet. We are told that they will instead come up with a PowerPoint presentation so that it will facilitate the distribution of the papers or the documents to the members of the court while it is being processed. So we may proceed, Mr. President.
The witness, the Honorable Ombudsman, will please take the witness's stand. We are at the stage of cross-examination. The prosecution may proceed.
Thank you, Mr. President. Honorable Ombudsman, did you advise the Senate that you are prepared with a PowerPoint presentation?
Yes, sir.
So, you earlier testified that on the basis of the information you received from AMLAC, you concluded that there are several bank accounts, and I'm quoting from your letter to the Chief Justice. There are several bank accounts in PS Bank and several other banks in your name, including those denominated in US dollars, the aggregate value of which amounts to at least $10 million. Do you confirm that?
Yes, sir.
Can you please explain to us, Honorable Ombudsman, how you arrived at the figure of $10 million?
Yes, sir. First, I listed all the different accounts. I classified them under one column. And then after grouping different accounts under one column, I got the dates the transactions occurred. Then I got the amounts the transaction occurred. But since I noticed that there were some accounts which were deposited in, let's say, A account, but on the same, let's say, 100,000, example only, but on the same day, the $100,000 were withdrawn in 3 tranches and transferred to 3 different accounts, X, Y, Z. I had a bit having difficulty trying to analyze. So I came up with some significant observations, and I put them into writing.
Can you please show to us these significant observations you've made in writing?
Yes, sir. That the Chief Justice has at least $10 million in transactional balances. He has 82 US dollar accounts in 5 banks. There were significant deposits and withdrawals on very significant dates, including the 2004 and 2007 elections, as well as the week he was impeached. Specifically for December 12, 13, 15, 19, 20, and 22, 2011, the significant transactions are as follows. On December 12, 2011, the day Corona was impeached, the following bank transactions were made. There was a time deposit for termination of $418,193.32. This amount was added to a BPI San Francisco Del Monte account number blank, blank, blank. And then from this, $417,978.80 was deducted from this account and placed in a regular trust fund contribution placement.
Your Honor, please.
Yes?
What's the pleasure of the defense?
At this juncture, Your Honor, we notice that the testimony of the witness is being in narrative form. May we request, Your Honor, that questions be directed to her so that we can properly object when the time so demands, Your Honor.
The question calls for an explanation, Your Honor, please.
Yes, but irrespective of what you want to have.
That is an answer, I think, to a question.
Yes, Your Honor, and we notice that the answer is being made in narrative form. It's practically a story. We can no longer object, Your Honor. That's why I'm requesting that this the testimony
All right,
of the witness be
all right,
adjusted by
to-
question and answer, Your Honor.
In order to be fair, will you kindly slice your questions in segments, Mr. Counsel, for the prosecution?
We will try to do that, Your Honor, but the difficulty is I just got this a few seconds ago. But I will try. Honorable Ombudsman, you were already testifying on how much were the withdrawals made by the Chief Justice from the date of his impeachment on December 12, 2011 forward. Do you have the total amount of dollars the Chief Justice withdrew after the date of his impeachment from the various bank accounts?
We object, Your Honor,
Why?
because the witness may be cross-examined only on matters directly taken up in the direct examination.
If Your Honor, please, the witness has been subpoenaed by the defense specifically for the purpose of addressing the $10 million. And now they are trying to limit her testimony. I think we should put it on record, Your Honor, that the defense has repeatedly misrepresented the supposed intent of the Chief Justice to open his dollar accounts.
We do not,
As early as February 12, 2011, this Honorable Court already ruled
Dito ba?
that the PS Bank accounts should have been opened. But it relented to the TRO, in particular because of the representation of the Chief Justice that he will open his account.
we have, if Your Honor, please.
Up to now, he has not done that. And now they are trying to block the testimony of the Ombudsman regarding transactions and documents which they specifically subpoenaed.
The rule says, and I'll read to you the rule of evidence involved. Section 12, Rule 132. The unwilling or hostile witness so declare, or the witness who is an adverse party may be impeached by the party presenting him in all respects as if he had been called by the adverse party, except by evidence of his bad character. Now, the rule now involved in this discussion is this. He may also be impeached and cross-examined by the adverse party, which is the prosecution now. But such cross-examination must only be on the subject of his examination in chief. So I'll have to sustain the objection.
If Your Honor, please, may I ask for a reconsideration?
Why?
The defense has already waived its right for the prosecution to cross-examine on the $10 million accounts. They expressly waived that, Your Honor, by making the representations they made last Tuesday and on the basis of the subpoena request they made. They already waived that, Your Honor.
If I may be allowed to answer, Your Honor. Maybe.
Go ahead.
There could be no waiver, Your Honor, because our objection now is predicated on the rule of evidence. We are not preventing my learned colleague from cross-examining her. But the cross-examination, being a hostile witness, Your Honor, must be only on matters taken up on the direct. Did we touch on the withdrawals? The answer is no. Did we ask her to testify?
Anyway, motion to reconsider is denied. Next question.
Honorable Ombudsman, who gave you this report from the AMLAC?
You are referring to the particular person?
Yes.
Yes, the executive director,
Who is he?
Vicente Aquino.
I noticed, Honorable Ombudsman, that there are initials. There is one initial on every page of both exhibits pertaining to the reports of the AMLAC. Do you know whose initial this is?
One of the officials of AMLAC or Central Bank, who is an analyst, bank analyst.
You earlier mentioned that you arrived at the conclusion that there were $10 million. Did you ask, did you request anyone to assist you in evaluating?
After my initial evaluation, I had to seek the assistance of the COA.
Who in particular, ma'am, in the COA?
the chair, Grace Tan, and then eventually I later requested Heidi Mendoza, the
And what
deputy
was-
commissioner.
What was their response to your request for
Well, they
assistance?
came
Again,
up with their analysis
again,
of dollar accounts.
Did they come up with a report on their analysis of
Well,
the dollar?
Your
came
Honor,
up-
please, before the Honorable Ombudsman answer, may we go on record, Your Honor, as again objecting to this. These matters had not been taken up in the direct examination, Your Honor.
Which
And
one?
if we have to be...
Which one?
The alleged report, the examination by the COA and so on, nothing had been mentioned about that in the direct examination. So following the previous...
Actually, counsel, the documents have been waived by the witness during her examination in chief. Di ba?
Yes, Your Honor, but the question now...
Pinakita niya eh.
Yes, Your Honor, but...
And it was solicited by virtue of a question from the defense.
No, Your Honor.
So,
May I-
see, the witness is now explaining who helped her, because that was the question
Yes, Your Honor.
of the cross-examining counsel. So,
Okay.
witness may answer.
May I request for the reconsideration, Your Honor?
Why?
The matters being sought to be listed on cross-examination, Your Honor, are matters not taken up in the direct examination. And the witness does not cease to be a hostile witness. The rules under Rule 132, Section 13, if I recall correctly, allows cross-examination. We are not denying them the right to cross-examine. But my point is, the cross-examination must be limited only to matters taken up in the direct examination. Now, the question now centers on the alleged examination by the COA, on the report, and on the examination. Our point is, this had never been touched in our direct examination, and I appeal to the records to buttress our argument on the point.
If Your Honor, please.
But don't you think the answer, the question to the ombudsman is because of the document that was presented to this court by virtue of the examination in chief?
No, what the documents...
He's explaining
Your Honor,
what happened, how that document was prepared, evaluated by her, and she said she sought the assistance of other people.
if Your Honor,
But
please.
anyway, okay, just to give you all the leeway to defend your client, counsel for the prosecution, reform your question.
Yes, Your Honor. May I just point out that in the request for subpoena of the defense, I quote that the Honorable Ombudsman bring with her the original and certified true copies of documents of the complaint against Chief Justice before the Office of the Ombudsman, as well as original and certified true copies of the documents on which they base their accusations that Chief Justice Corona has foreign denominated accounts with an aggregate value of $10 million. These are the words of the defense when they asked for the subpoena. And now they're trying to prevent the witness from testifying on the very documents they subpoenaed, just because they now know that the contents are adverse to them.
We are afraid, Your Honor, that we had been misunderstood. We never have referred to any subpoena, much less to any subpoena ducis tecum. That had not been part of the direct examination of the witness.
Therefore, you directly examined her on the basis of matters that were not subject of the
What we are
subpoena.
objecting is the question propounded to the witness, which covers subject matter that has not been taken up in the direct examination. That is
Anyway,
very clear.
counsel for the prosecution, please reform your question so that we will not go into this lengthy discussion.
Yes, Your Honor. You earlier said, Madam Ombudsman, that you are prepared to present a PowerPoint.
Yes.
Can you do that?
Yes, sir. If the impeachment court will allow me, Your Honors.
If Your Honor, please.
Unless I'm reversed by the... Yes, what's the pleasure?
If it's not part of our direct examination. And secondly, Your Honor,
If Your Honor, please.
Allow me to continue.
I vehemently disagree with the statement that it was not part of the direct examination.
Your Honor, please.
The journal will bear me out. They asked questions regarding the basis for the $10 million.
Right. Oh,
Now that the
Where is the
evidence is
PowerPoint?
adverse to them, they're trying to suppress it. May I point out the presumption in the rules of court that when evidence is suppressed, it is presumed to be adverse to the party suppressing such evidence.
you're misquoting a wrong law. That does not apply in this particular case. Do we have a right to object? Our answer is yes. It's addressed to the Honorable Court.
Did you not ask a question about the basis of the charge that the Chief Justice has $10 million?
Yes.
We did not discuss on that in the direct
Did you ask
examination.
that question?
Yes.
I do not recall, Your
Well,
Honor.
let's go to the record.
My question is what
No,
is...
Let us not discuss this. I want to see the record if indeed the defense counsel did not ask anything about the basis of the $10 million that was the subject matter of the examination in chief. What's the pleasure of the gentleman from Taguig?
Mr. President, just to save time and to support the earlier ruling of the chair, during the direct examination, tinanong po ng counsel, bakit hindi mo nilagay sa sulat yung basihan?
Yes.
At ano yung basihan? Ang sagot po ng Honorable Ombudsman, ang basihan niya yung dokumento sa AMLAC. Natandaan ko po to kasi 4 na beses niya po winagaygay.
Winagayway.
Sorry po. Excuse my Filipino. Anyway, she held it up and waved it. And we were teasing Senator Jinggoy na kumuha na tayo ng kopya baka mawala. And paulit-ulit po yung ombudsman in saying na para tayong sirang plaka, hindi ko sinama to sa letter sapagkat she didn't think it was needed na ilagay sa letter. Therefore, Mr. Chair, to support the presiding officer, winagay niya na yung wagayway. Kanina pa niya winawave yun. And secondly, Your Honor, not to debate with you, kasi kung bubuksan pa natin yung record, hahaba pa, or kung yung pronunciation sa Tagalog ayusin ko, hahaba pa. So excuse me for that mistake. But the defense is the one who brought up the AMLAC records. Ang ginagawa lang ng prosecution ngayon, nag-elaborate o hinihimay. And the PowerPoint is para tulungan na ihimay. So I'll stop there, but I'm supporting the ruling of the chair that it is proper in cross because it was brought up in fact by the defense, except hindi nyo hinimay o hindi nyo na tinanong yung ombudsman kung ano yung laman. But yung the fact na meron pong papeles na galing po sa AMLAC, nanggaling po yun sa tanong ng defense. And I'm afraid nahahaba po, tatagal po tayo today kung babalik pa tayo sa records and every single question. Kasi po, pagkatapos nyo po, magtatanong din kaming senator judges at hawak na po namin kopya namin, magtatanong din kami. So without interfering in the way you will defend your client, and I understand you have to do this, these questions will come out, sir. And I just like to put on record that I'm supporting the Senate President's stand that this was brought up. And I hope maging smooth yung pagtatanong natin dito.
Thank you, Mr. Senator. What we are objecting is the utilization of PowerPoint, Your Honor. True. But when there was a statement to the effect that this came from the AMLA, I recall having questioned, cross-examined the witness, Your Honor, on several matters regarding the AMLA, and the net effect is that she is not in a position to testify on matters properly within the confines or jurisdiction of the AMLA. That's why I stop in there. I did not insist, Your Honor, that she should be examined in connection with how the matter was brought to the AMLA, what investigation was conducted by the AMLA, why it is confidential, why there is no predicate crime, and yet there was an information supplied to I totally withdraw all my statements
What
relative.
is the pleasure of the gentle lady from Rantique?
Thank you, Mr. President. Isang maliit na kahilingan lang po na sana po ay bigyan natin pagkakataon na si Ombudsman Morales ay makapagsalita na dahil 3 oras na po tayo nakaupo dito. Gusto po natin marinig ang kanyang pahayag dahil meron na po tayong kopya ng 17 na pahina dito. Pero mahirap intindihin dahil puro numero po at mga codes. Yun ang po hinihiling ko. Pakinggan natin siya with minimum interruption at yung mga abogado dito at saka doon po, with all due respect, mamaya po magtanong, pwede po mag-redirect naman po siguro ang defense, pwede magtanong siguro sa tamang pamamaraan ang prosecution, tas kami, bibigyan po ng pagkakataon kung kailangan pa. Pero paano po tayo magkakaintindihan, bigyan po natin ng pagkakataon para mapaliwanag yung mga numerong napakaraming hindi namin maintindihan. Salamat, Mr. President.
With due respect, Your Honor, I think with the least bit of contradiction, we are agreed that this alleged report came from the AMLA. As to who prepared the same, in particular, whether he's under oath, whether we can cross-examine him on the veracity of the entries here in appearing, whether they are authentic or not, we are already helpless, Your Honor. We are and the presentation.
Your Honor, the document was testified to by the Ombudsman. It is a part of the testimony. You know that is a rule in evidence. Any document presented to witness and used by her in the course of her testimony, in this case, is a part of the testimony of that witness, which could be the subject matter of a cross-examination. Now, you are objecting and you say that you did not touch upon that matter in your examination in chief. I agree with you that the COA was never mentioned by the Ombudsman, but precisely she was asked. The way I understood the question of the prosecution is that the prosecution asked the Ombudsman whether that document was prepared by her, and my recollection of her answer was that she asked the help of some other people, including the COA, if I understood her correctly. So that is in answer to the question of the prosecution. But just to satisfy the objection and to be sure that we are not guessing here, I am, as the presiding officer, I want to check the record, because my recollection of the record is that you, the defense, really touched this matter in their examination in chief.
My point of objection, if I may be allowed to continue,
Yes,
Your
please, go
Honor.
ahead.
My point of objection is not only whether it was not touched in the direct or not, but whether the witness will be competent in so far as AMLA figures are concerned.
We will establish that, Your Honor. We haven't finished our
What is being
examination.
presented now is an AMLA report
That
unsigned.
that will be a proper subject of a recross or a redirect.
Well, maybe
A redirect, because in your redirect you can actually cross-examine the witness.
yes, Your Honor, but
We have already declared her to be a hostile witness.
we are very appreciative of that, Your Honor. But our point is, apparently there is no competency on the part of the witness to discuss this report, because first, he is never a party. Then,
They'll show that in the course of your recross.
no, but
or redirect.
my objection, our observation.
Are you objecting on the ground that the Ombudsman is incompetent to testify on this matter?
On the AMLA report, in addition to our previous objection, Your Honor,
Your Honor,
because
please, we have
it is not
yet
shown
read-
yet whether she is a party to the preparation thereof, whether she is privy to the entries therein appearing, and whether he had talked to the person who made the entries, Your Honor.
Yes,
So this will be a paper presentation.
correct, but she's simply reading from the report.
Precisely, Your Honor.
So,
PowerPoint presentation. This will include interpretation, Your Honor, of figures stated in there.
well, if you do not want a PowerPoint presentation, then I will submit it to the body for a decision. if you're objecting.
That's my point, Your Honor, and I made clear our position on the matter, Your Honor. We are heavily thankful to the court for allowing us to say our piece on this particular and specific matter.
If Your Honor, please, just for the record, I have not seen these documents, and the mention of the PowerPoint presentation, I heard of for the first time from the Honorable Senator Soto. And I thought it was a wonderful idea to expedite the presentation of the evidence. It did not come from the prosecution. It came from the senator. Now, if the ombudsman is ready to come up with a PowerPoint presentation, I think it's within the discretion of this honorable court to say yes or no. But definitely, it's not barred by any rule.
It may be tedious, but if you want to, you object to the power presentation, then I will direct the prosecution to ask the specific questions so that you can object.
Thank you, Your Honor.
All right?
Mr. President, may we recognize
The
Senator Marcos?
gentleman from Ilocos Norte.
Thank you, Mr. President. Just a quick question to Madam Ombudsman. We thought we would be able to figure out these figures, but as you can see, there are very many items under which these transactions are categorized. Madam Ombudsman, you used a term earlier, transactional balance.
That's right.
What does that mean exactly? So just because it's so hard for us to
The transactions that went into funds, the transactions that, including the inflow and outflow of funds, that is not the balance of the account.
I
Those
see.
are the balance of the.
So that is the total. In other words,
that went through the system of his.
exactly. So in other words, all the dollar transactions, when added together, are total $10 million. Was that the determination that you made?
It's even more, I think.
It's
Your
even
Honor.
more. So it is not the balance. It is.
It's balance of transactions.
So even if let us say $10,000 was deposited,
Yes.
and subsequently $10,000 was withdrawn,
Yes.
that will be a transactional balance of $20,000. Is that correct, Madam Ombudsman?
Let's put it this way, Senator. I think my computation, which was arrived at with the assistance of CPA lawyers, is that his fresh deposits, which means fresh deposits, they never moved, they remained in that particular account, amounted to more than $12 million.
Yes, but
Fresh deposits. But the transaction, we're saying the inflow and the outflow, that's it.
I heard you specifically say that the transactional balance to your determination was $10 million.
Even more.
Even more. But again, so it does not denote the balance. It merely denotes the total
Yes.
amount of money that went
yes,
through the
it
system.
does not denote the balance of the account.
Okay.
But as I said, Mr. Senator,
Yeah.
his fresh deposits amounted to more than $12 million. When I say fresh deposits, they were never moved from one bank to another. They stayed in those accounts.
Very well. We'll have to plow through all this information. Thank you very much, Madam Ombudsman.
Yes.
Thank you, Mr. President.
If you allow me, it will abbreviate the proceedings. If you allow me to come up with a power presentation, it will be easier to be understood if you allow.
Madam Ombudsman, there's an objection from the defense.
All right.
So
Okay. The senator from Iloilo.
Senator Santiago, Mr.
the
President, is
gentle
asking
lady
for the floor.
from Iloilo.
Mr. President, the primary rule in the rules of evidence is relevancy. In fact, it is one of the first few articles that open the section of the rules of court concerning evidence. As long as evidence is relevant, it is admissible in court. There is no prohibition in the rules of evidence of a PowerPoint presentation. There is no categorical prohibition of such means of introducing evidence. The only question facing us is this relevant? I hold as a judge that this is relevant, therefore it should be admitted. And besides, it will help us considerably to reduce the hours that we might spend going over these items one by one. If there's a need for voting, I vote therefore for the PowerPoint presentation.
Order. Order. May I request the public to refrain from showing your approval or disapproval with things that are happening in the courtroom. So order. The gentleman from Cavite.
If there is a need for a motion to be submitted to the chair to allow the ombudswoman to present through a PowerPoint presentation, I so move, Mr. Presiding Officer.
All right, there's a motion to allow the ombudsman to present a power presentation of the report prepared by the AMLA to her. May I request those who are in favor, please raise your right hand. All right. Those who are against, please raise your right hand likewise. Against. Those who are against. No one is against? All right. The power presentation is authorized by the impeachment court. Proceed.
All right. If Your Honor, please, if you will allow one of my if one of those who assisted me in charting this visual aid in coming up with a presentation to herself present. I am referring to Commissioner of the COA, Heidi Mendoza, if you will allow her to do the presentation, or you will prefer that it's going to be me.
Well, if you are technically capable, Madam Ombudsman, then,
I'll try, Your Honor.
All right. Please do so.
All right.